This is the plaintiff, Wayne Brown. He says he purchased a van from the defendant. The thing failed inspection. Then a month after he had it, the engine completely blew. Turns out the defendant had replaced the original engine in the van with a car engine. It was overloaded, and that's why it blew. Since the defendant never told him this, he feels he was rooked and is suing for the return of his hard-earned $7,000. This is the defendant, Rodrigo Rebello. He says he drove the van over an hour away to the plaintiff's mechanic to check it out before he purchased it. The guy gave it a clean bill of health, and he sold him the van. Now he blows the engine in the thing, doing God knows what, and wants to return the van? Is he serious? He owes this joker no money, thinks the judge will rule in his favor, and will send the plaintiff packing. He's accused of moving motors.
All parties, please raise your right hand.
Welcome back to the People's Court. Next case in the docket, the plaintiff bought a van from the defendant and says the engine blew, but the defendant says it's his own fault. It's the case of Van Go, and Van doesn't go.
Thank you, Douglas.
You're welcome.
Wayne Brown, you are suing Rodrigo Rebello for $7,000. According to you, your damages actually exceed that by several thousand. And what it's going to cost you to repair a lemon that you say he sold you. Tell me what happens.
Well, I answered an ad that he had on Craigslist for a commercial truck. Excuse me, that was for sale. I'm a contractor, and the truck is a old Verizon truck, so it has a generator and a compressor built right into the truck. So when we come and do a service for someone...
What kind of business are you in?
General contracting, so we do remodeling.
So you would
repairs.
have your own power?
We usually bring our own generator, but buying this truck, we would pull up with the truck, turn the generator on. Now we use our own power instead of using the homeowner's power in case we trip a breaker or something like that, you know. So I inquired about the van. He ended up bringing it to a job site I was at. We couldn't get the generator to turn on. I said, I'm interested, but obviously not if it doesn't have its own power. A week later, he said he got it running, asked us to come look again. So we drove up an hour from where we live to where he lives, got the thing to turn on, but the generator wouldn't stay running. So he said he would take care of the generator. We'll get the truck working if you want to buy it. I said, I'm interested. I want to buy the truck.
This wasn't enough of red flags for you that twice now the thing doesn't work for its intended purpose for you?
Well, the truck runs, but the generator didn't. So
yes, twice.
Yes.
So if you're buying it just because of the generator, well, how come you don't move on? Are these rare?
Yes, they are. Okay. They're hard to find.
Okay. Was the third time the charm?
Well, the third time he dropped it off. He drove back down to a shop in Kingston, and I wanted to make sure the generator ran. So the generator ran.
What do you mean a shop in Kingston?
The shop that my mechanic shop.
Oh, you had him take it to your mechanic?
Yes.
All right, and then obviously his advice was go ahead?
Well, he said he took it for a ride and said it's going to need brakes, but it could just be because it's a heavy truck. It's a 12,000 GVW truck.
Okay.
I said, okay, well, I'll let him know. And I said, you know what? We'll buy it. Don't worry about it. The following day, he drives down to my house. That was on the 21st of March.
What was he asking for the 2000 GMC Savannah van with?
$7,500.
Okay, and then what happens?
He came, picked up the check, signed over the title.
Okay, was there a bill of sale?
Yes.
May I see it?
Thank you, sir.
Okay, who wrote this contract?
I typed it up.
Yeah. Okay, so here's what the contract says. I, Rodrigo Rebello of such and such an address, am selling my van to Wayne Brown of such and such an address for $7,500. Truck is being sold in working order and expected to pass Massachusetts motor vehicle inspection in accordance with Massachusetts lemon law. If truck does not pass the inspection, do you know what Massachusetts law requires? Only that if it fails to pass inspection in the first 7 days, and he has certain responsibilities, the buyer has to take it there and get it inspected, that if it fails, either you give him his money back or you help him pay for the repairs to the tune of 10% of the purchase price. It's capped at 10% of the purchase price. But apparently, you put yourself on the hook for more than that in this bill of sale, because he's very smart. He writes it to, I don't blame you, to protect him. And what he writes is that you'll be responsible for repairs needed to pass inspection by signing this contract and the cashing of the bank check. Both parties agree to the sale of this dollar amount and the warranty that you are giving. But you're in here saying that you're going to pay to pass inspection. What if it's more than 10% of the purchase price?
So the car wouldn't start, the van wouldn't start twice. Kind of a red flag here. Would you buy that van?
Absolutely not. That's too much risk.
What if the guy said the van's worth $1,000, it'll give it to you for $400?
No, still not. I mean, it's practically worth nothing.
Would you buy that van?
Absolutely not.
How many times does the engine not have to start when you're looking at it before you say goodbye?
The first time is good enough.
And the fact that it happened 2 times and then he still bought it?
Then he's a dummy.
Dummy. Okay, going inside the courtroom. Secret word.
So you take possession of the truck and what happens?
Well, the 23rd we register it.
Okay. You bought it what day?
The 21st.
What day do you take it for inspection?
The 23rd.
Okay.
And it failed.
Okay. Let me see the failure.
All I have
Oh,
is
you best have the failure. You best have the failed inspection report.
what I have is the mechanics.
No, I don't want to see what things you decided to do to a car. I want to know what things you had to do to the car. Okay? That means I want to see the 1, 2, 3, 20 reasons you failed so that I can see how much of the bill that you paid was because of your failure. Mm-hmm. Because otherwise, a litigant could walk in here, have 20 things taken care of, and tell that poor sucker that he's got to pay for all of them. So show me the failure.
They didn't give me the failure on the printout. They gave me their invoice for it to pass inspection with the receipt.
Let me tell you how it works. You're in court arguing that the thing failed. And my needs are so simple. I'm not a difficult woman. Just prove to me it failed. You see? You got to prove to me it failed and why it failed in order to have any of that taken care of. Now, as I understand it, he comes to you and says what?
I brought my own bill of sale, but he denied on that because I could have sold as is. And until then, everything was perfect with this deal. He even offered me a job working with him after this happened. And what happened is after he's getting I fix all little things on this truck, which he sent me that copy of that. Never received a reject. Until then, trusting in this guy.
Why would you trust in him?
I was planning to work for him. All right,
we all make decisions based on what's best for us. At the time you needed the money, you wanted to sell the thing, you thought you might be working for the guy, and so what do? You end up sending him a check.
I only can offer you $500 for we settle this deal, and that's it. I choose to lose $500. But get this out of my plate, and that's it. Now,
you didn't want to work for the guy after that, right?
I don't want to deal with anything else.
Okay.
Exactly. Because I'm probably...
All right. So
I'm not going to say.
Okay.
What happened is, I did send a check. I got the...
Wait. When you told him, I offer you $500, what did he say?
He agrees with that.
Okay, I'm sorry. How did he agree? Through text, through email, through...
Emails.
Do you have the emails?
I do.
Let me see them.
I'm going to send you 2 copies. The second one was about the job he was offering me to be working for him.
Rodrigo, I hope things are well. Here's the paperwork from the mechanic. Let this letter serve. So he never showed you that he failed inspection?
No, unfortunately.
So as we're all standing here, none of us know for sure whether he failed inspection.
No.
Dude, you wrote him an email saying you'd take the $500 and that it would be settled. It will be the last that you are responsible for the GMC van. And yet, after that, you are now not only suing him for the rest of what that $500 represented, which you settled, so why, but you're suing him for a motor because you later find out other things, right?
No, Your Honor. First, that was the only reason he would even send me the check is if I wrote that. He says he supplied it.
Yeah, just like I looked at him and said, tough for you, tough noogies, because you gave him the warranty. Well, tough for you, tough noogies, because you entered into what we call in the law an accord and satisfaction. It's a contract that 2 people who are going to be litigants make saying, you know what, let's settle this. What do you think is the effect of a settlement? You get to cash a check, and then you get to march into court anyway?
Okay. He did rear brakes. He admitted that he only did rear brakes on this truck.
Mr. Brown, enough, okay? You're a mere mortal like the rest of us. And when we agree to end a case, that goes for you too, not just for everybody else in the litigation world. When you turn around and extract another $500 from the guy after you've already gotten it down $1,000, after you've already had him fix 500 different things on it because you know the guy's desperate to sell it, all right? And then after you bring it to your mechanic and your mechanic tells you it's a good deal, because that's why you brought it to your mechanic, then after all that, you end up getting the guy to pay another $500 and you promise him that that'll be the end of the last year responsible for me for this GMC van. Yeah, I'm going to make you stick to that. That's the last he's responsible. Verdict for the defendant.
Wow.
Well, the plaintiff was still talking after the judge ruled against him right here. So what was it that you were still saying in the courtroom? Come on over.
The fact is, he sold a truck that he already replaced an engine, and we didn't even get to explain it. He said the truck has been run, being used by him every day for 3 years, yet he had an engine replaced from a truck and put a car engine in, but we never even got to discuss it.
Yeah, well, what about the $500 agreement that you offered him in the email?
Well, that was only so that we could get some money out of him, and then the rear brakes blew out.
That's a contract, though. That is a contract, and it's legal, and you're bound by it.
Yeah, well, actually, by the law in Massachusetts is when I asked for my $7,500 back instead of getting an inspection, that's what I should have gotten instead of a check for $500 in the mail.
Well, you got to stick to what you agreed to.
All right, guys, right this way.
All right, so you step on in here, and what's your feeling on what you just heard?
I think she's honest. At least.
She's honest?
At least everything came the way it should be. Because all the proofs we have, everything, he thought I'm maybe an easy guy to be taking money.
Did you realize what you signed with him? Did you read that deal where you agreed?
I read, but I didn't
you were obligated
understand.
to do more than the law said.
I trust in the truck. I have fixed myself. I have the proofs, everything, and I have worked with the truck.
Read what you sign and understand it before you sign it.
Correct.
Harvey?
Okay, Kurt, if you make a bad deal, it doesn't matter that it's bad. You can't say to a judge, I made a really bad deal, Your Honor. You are stuck with a bad deal.